Well, if attendees can ask questions, it can be by email, right?
Yeah, then you gotta tell them.
Uh,
So then what I'll do is
where would the questions come up?
uh,
Would they come up on the screen?
no, here. The questions here. This right? The question.
Mm-hmm.
So they will come up here.
Mm-hmm.
So then you just type.
I don't want to do it. Let's just make it easy. What's this one? Is she around?
So
Star one. Yeah, did I kick this off? Testing, testing, testing. Can you hear me, Elizabeth? Can you hear me? Hello, Daniel. Testing, testing. Can you hear me? Testing. Testing for this event. What? All right. Do they know how many attendees are there, or they don't know that?
They don't know.
Good. So there's only one.
So, all so I guess what populate the people.
Maybe. I think we had like, what, 11? So that means 4 will show up. I don't care. It's marketing for the day property.
Also,
Good afternoon. As we wait for others to join the webinar, we're going to get started at exactly 1 o'clock, and we will proceed through this seminar. Thank you very much for attending. It's my pleasure to conduct this webinar. I think you'll find it very helpful, and my expectation is that after completion of the webinar, you'll have a much better understanding of the new state rent control and just cause eviction ordinance. As many of you know, I'm Daniel Bornstein. I'm a broker with Bay Property Group. It's my pleasure to continue to serve as broker of record for Bay Property Group. I am also a practicing attorney handling landlord-tenant issues throughout the Bay Area, with a particular emphasis on understanding the confluence between rent control and local jurisdictions, as well as now the state ordinance. It is a very, very new era, and it is particularly difficult because the statute that we are now faced with understanding is not well written, and we will only learn over the next decade the change will arise and the changes that may occur as courts start to digest the rules and regulations regarding the state ordinance. So let's begin the seminar and let's move screens. What I'm going to do today is I'm going to go through the state rent control just cause eviction ordinance. I'm going to also discuss tenant buyout and why they have become that much more prominent. And then for those of you who have questions after the webinar, all I ask you to do is email me, and I'll be glad to respond by email to any questions people have. So let's jump in and go through the particular nuances of the state ordinance. And when we talk about the state ordinance, we have to remember there are two components of it. There's state rent control, and then there are just cause eviction rules. And we're going to treat them separately because there are separate rules for each. So the general rule, when we go throughout California, is that all residential rental property in California are subject to the state ordinance unless they are exempt. Let me repeat that. All residential rental property in California is subject to the state ordinance unless they fall within an exemption. And of course, I will go through the exemptions, but when you're traveling throughout California and you see a multi-unit property, you immediately are able to say, well, that may be subject to the state ordinance unless it's exempt. The one threshold issue is that in order for a tenant to be protected under the state rent cap or just cause eviction ordinance, they must be in possession 12 or more months, which brings up this point. Strategically, it may be very prudent for a landlord to sign initial lease agreements for less than 12 months, because until the tenant has been there 12 months, they're not entitled to the protection of the ordinance, which means you have a tryout period where you could potentially end the tenancy before they segue into rent control or just cause eviction rules. So again, all residential rental property are subject to the state rent and just cause eviction rules unless they are exempt, but the tenant must be in possession 12 or more months. Let's move on. State rent caps. So now we're going to focus solely on the rules involving rent increases. And the maximum rent increase that you can provide a tenant in any 12-month period is the equivalent of 5% plus the consumer price index for that region, or 10%, whichever is lower. So what we have is a yearly rent cap of approximately what will look like 7 to 10% a year. Not terrible, but it's the first time that we are faced in California with state rent control. And remember, you have to have been in the unit more than 12 months in order to avail yourself of this right. And then the rule is no more than 2 increases in any 12-month period. And the one item that's particularly confusing and cumbersome is that this rule, though it became effective January 1st, is retroactive to March 15th, 2019. And you see that highlighted in red in the top corner. What that means is if you raise the rent in a multi-unit property in, let's say, Walnut Creek, over 15% in June of 2019, you have a bad rent increase and you're going to have to correct it. My advice is make sure you look at any of your increase history between March 15th and the present and see if you've raised the rent more than the allowable limit, because if you've done so, we've got to correct it. And again, this applies to all state regulated properties unless it's exempt. And let's move on to the exemptions. Exemptions. And this is the big ticket item that you have to understand. If your property is already subject to a local rent control ordinance, such as your property is a multi-unit property in San Francisco, a multi-unit property in Berkeley, a multi-unit property in Oakland, since you are already subject to a local rent control ordinance, you are exempt from the state rent control ordinance. What this means for all of us in the Bay Area is the local ordinance is worse. So under the state rules, you can potentially raise rent between likely 7 to 10% a year. Of course, we know in Berkeley, San Francisco, and Oakland, we're looking at 3%, if not less, a year. Another exemption, single-family homes and condominium units. So single-family homes and condominium units throughout the state of California are not subject to state rent control. Let me say that again. Single-family homes and condominium units are not subject to state rent control, except they will be subject when there's corporate ownership, LLC ownership where one member is a corporation, or REIT ownership. In that situation, those single-family homes or condominium units will be regulated under the state rent cap. Another exemption is if the building was built within the last 15 years. So if your building was built in 2018, it's going to be exempt even though it's a 20-unit property. So we got a 20-unit property built in Walnut Creek in 2018. It's exempt until it becomes 15 years of age or older, and that's a rolling target. Public housing, dormitories, and duplexes where an owner lives in one unit since the beginning of the tenancy in the other unit, also exempt from rent control. Be advised, commencing July 2020, the exemption must be disclosed in leases. So all of us are going to be using new leases as of July 2020. And my recommendation is that new tenancies starting now should have the disclosures embedded in the new leases, or notification be given to all tenants, obviously before July 2020. So these are the exemptions for state rent control. Single-family homes, condominium units, properties already subject to rent control, and new construction, 15 years or less. Now let's segue into state just cause eviction. So we talked about rent control. Now we're going to talk about the ways in which you can terminate a tenancy. It used to be, before January 1st, 2020, if I had a multi-unit property in Walnut Creek and a tenant was month to month, I can terminate their tenancy if they've lived there over a year on 60 days notice, if they've lived there under a year on 30 days notice, without any justification. Simply, I was terminating a month-to-month tenancy. Now in California, you must have a just cause unless the property, again, is exempt. What are the just causes under the state ordinance? Non-payment of rent, breach of a covenant of a lease, and I put an asterisk on this. You must provide the tenant an opportunity to cure, and if not cured, then you can proceed. This also means that we want to use the best leases around, because it's so imperative that we have a great lease agreement, because this is one way to enforce tenant compliance. Nuisance, where a tenant is engaging in unlawful, unreasonable interference with the use and enjoyment of property. Waste, where a tenant causes a fire, whether intentional or by accident. Failure to renew a lease. Criminal activity. Assignment or subletting. Failure to provide access when demanded for inspections. Using the premises for an unlawful purpose. And it's a tenant's failure to vacate after tenant provides notice of termination. So if your tenant, let's say in a multi-unit property in Walnut Creek built in the 1970s, gives you notice that they're ending their lease agreement, you can accept that notice, and if they don't move out after giving you notice, you can terminate the tenancy under the state ordinance. In San Francisco, a tenant's right to rescind termination is absolutely. So you're out of luck if you're subject to the San Francisco ordinance. An occupant's failure to vacate after termination of employment. So if you have a resident manager and you terminate or end the resident manager employment, it is a just cause under the state ordinance. Now, we've talked about good cause under the ordinance, but there are some causes that are no fault evictions. And here's where it gets tricky. A no fault termination is when it's no fault of the tenant that their tenancy is being terminated, such as an owner move-in, OMI, or a relative move-in, It's where an owner seeks to move into a tenant's unit, or an owner seeks to have a relative move in to the tenant's unit. Effective July 2020, if you want to preserve your right to an OMI or an RMI, you must disclose your right in the lease agreement. Ellis Act, where you want to go out of the rental business, it's a just cause. It's also a no fault. If your building gets red tagged by the city because of a fire, you can terminate the tenancy. Or if you want to demolish or substantially remodel the premises, you can actually have a just cause. The rule is, now, under the state ordinance, if you seek to terminate a tenancy for a just cause, you must provide the tenant either a rent waiver equivalent to 1 month's rent, or you must pay the tenant 1 month's rent within 15 days of service of the notice. While this may be the first time in California, owners are going to be obligated to pay a tenant when they terminate for an owner move-in eviction. In San Francisco, Berkeley, Oakland, we've had relocation payment obligations for a long time, and it's not 1 month's rent. For example, in San Francisco, if you have a tenant who you want to do an owner move-in eviction, and they've lived there over a year, you've got to pay them $6,890, not 1 month's rent. So the amount is relatively benign under the state ordinance. Let's go over the exemptions for the state ordinance. Exemptions. Again, for most of us in the Bay Area, especially in Oakland, Berkeley, and San Francisco, if your property is already subject to the ordinance in Berkeley, you're exempt from the state ordinance. You follow the Berkeley ordinance. If your property is subject to the Oakland just cause eviction ordinance, that's what you follow. You ignore the state ordinance. You're exempt. If your property is a property that is subject to a new ordinance commenced after September 2019, and the new ordinance is more protective, then you follow the new ordinance. For most of us, though, what we're either going to be faced with is properties that are already subject to the local ordinance, or we segue into the state ordinance. Again, single-family homes and condominiums units are going to be exempt for just cause eviction rules under the state ordinance. So a single family home in Walnut Creek will not be subject to just cause eviction rules and not subject to rent regulation, except where you have corporate ownership, LLC ownership, or where when one member of the LLC is a corporation, or we have REIT ownership. Again, if we have a newly constructed building built within the previous 15 years, it will also be exempt. So buildings built between 2006 and the present are right now exempt. You built a property in Contra Costa and there is no local ordinance in Concord, then you're going to be exempt if it's new construction. Once it becomes 16 years old, you've got yourself subject to liability for rent cap under the state ordinance and just cause eviction rules under the state ordinance, which means if you're looking for properties throughout California, you now got to be very, very aware of the ordinance so you don't make a mistake and purchase a property that you thought was free from the ordinance, only to realize that in 2 years it will be subject to it. Public housing entities, dormitories, again, duplexes where an owner lives in one unit, tourist or transient hotels, nonprofit elder care hospitals, a tenant who is a roommate of an owner, so an owner who has a roommate in a single family home, of course, exempt. Owner occupied single family home with an accessory dwelling unit, exempt. And the only real big ticket item is that now there are disclosure obligations that you must provide by July 2020 in your lease agreement in order to ensure that you remain outside of the ordinance if your property falls within exemption under the state ordinance. The big ticket item to remember is this. Again, if you're subject to Berkeley or Oakland or San Francisco just cause eviction rules, you still have to comply with those obligations. Let's go over the disclosure requirements. So, what we are looking at is in new lease agreements, we have to include this language about the limitations of the rent ordinance in order to be able to avail ourselves of being outside of the ordinance. All of California is now responsible for updating your leases. If you have an existing tenant, you're going to want to provide them the notification necessary. Of course, if you are a client with Bay Property Group, we'll be providing these notifications well before July 1st. And for new tenancies, this will be part of our process by which we sign new lease agreements, providing the necessary disclosure documentation so we are compliant with the new regulations. Rent increase disclosure requirements. An owner of a residential property must provide this document either in a signed document by the tenant or an addendum to the lease agreement. And you've got to do this by July 1st. There is a nuance as to August 1st, but most importantly, let's get these documents together and out there. And remember, if you order a new California Apartment Association or a San Francisco Apartment Association lease agreement, you're going to have these disclosures embedded. Most importantly, you're to throw out your old lease templates and make sure you update all your leases so that these disclosures are embedded. The concern that we have is if you don't have this disclosure, even though your property may be deemed exempt, because you failed to provide these disclosures, a good tenant attorney could argue that you didn't provide the disclosure, so you have to follow the rent increase rules of the state rent control rules. Disclosure requirements, preserving owner and relative move-in rights. As discussed, one no fault under state law is an owner move-in or a relative move-in. You have to pay the equivalent of 1 month's rent, but you have to embed this little disclosure in your lease by July 1st or you're out of luck. And let's imagine this. Imagine if you didn't include this disclosure, then you went to sell your duplex, and all of a sudden, the new buyer attempts to do an owner move-in eviction and the disclosure is not embedded in the doc. This occurs in February of 2021. Because you didn't have the disclosure of the notification requirement, a tenant in that unit could rightfully defend the owner move and eviction by claiming they weren't given the disclosure. So it's imperative that everybody is upgrading their leases, because we are going to see an abundant amount of litigation in the future on owners who have been sleepwalking through the last 12 months into the future, using old lease agreements that they have in their file cabinets, not realizing that they have made a horrific mistake, and they've set new owners up, successor buyers up, with the inability to accomplish the goals they may have set for themselves at the commencement of the purchase, such as an owner move-in or a relative move-in. What does this mean? It ultimately means that because now multi-unit properties throughout California are going to have tenants who are protected under the rent ordinance and or just cause eviction rules, it's going to make it even more attractive to negotiate voluntary agreements for tenants to move out in exchange for compensation. My office has been doing buyout agreements throughout the Bay Area for many, many years. As the regulations increase, as more and more people become aware that a vacancy is worth more money in the value of a building, more and more people are looking to negotiate voluntary agreements for a tenant to transition out, as opposed to inheriting a below market unit when they purchase a property. So for instance, if you were to look at a Walnut Creek 5-unit property built in the 1960s, it's now subject to just cause eviction rules and rent regulation, assuming each of the tenants have lived there over a year. If I were choosing to sell that building I own, and I knew I had tenants who were below market, let's say $500 below market, I would, before I went to market the property for sale, I would see if tenants would be interested in potentially transitioning out of the property for compensation. Because if I could deliver a vacancy, I could deliver a unit that is worth more money, because you can always rent a vacant unit at market rate rent. Arbitraging vacancies has always been a core component of places where they already have existing rent control ordinances, and now this whole arbitrage is going to be occurring throughout California. And this is the unintended consequence of state rent control and just cause eviction rules. It just increases the value of a vacancy and ends up creating a whole speculative market for people looking at properties to see which units may be attractive to reach agreements for a tenant to voluntarily move out. I will tell you this, it is perfectly legal and perfectly ethical to negotiate a voluntary move out with a tenant when you are faced with a jurisdiction like California, where you have rent control and just cause eviction rules. There's nothing in the new ordinance that precludes it. My office can prepare these agreements within 48 hours. All I need is this information: the name of the owners, the name of the tenants, the address of the unit, when are the tenants vacating the unit, how much are you going to pay them, when are you going to pay the tenant, is the tenant going to continue to pay the rent, and are you returning the security deposit, or is the tenant forfeiting the security deposit? With those 8 questions answered, I can draft up a buyout agreement for you. It's my pleasure to be of assistance, especially for those people who are working with Bay Property Group in managing properties. I will say there are properties in San Francisco, because they may be subject to San Francisco just cause eviction rules, but they may also be subject to state rent regulation, that we're going to have a tricky process. So if you have properties that you want to discuss with me, just email me. And today I'm going to be available at daniel@bornstein.law, and I will be glad to answer the questions people have regarding this webinar, or questions people have regarding what I've covered, or a particular question regarding your property and what strategy to pursue. It's my pleasure to be of assistance, and it's my pleasure to provide you guidance in all of your decisions about your rental property. Most importantly, remember, the goal is to avoid an unlawful detainer action if possible. The state rent control ordinance and the state just cause eviction ordinance did not change the eviction process. It's the same process as before. We now, though, have to have a just cause to terminate if we're dealing with rent control property. The eviction process typically takes, after a notice expires, 6 to 12 weeks to reach its conclusion. This is a chart that has not changed as a result of the new regulations. And when people ask me, Mr. Bornstein, how difficult will a termination be? I always tell them our goal is as fast and as cheap as possible, taking into account attorney fees, time, and risk. But the biggest variable we have no control over, which is which attorney the tenant gets and how hard they fight. And now throughout the Bay Area, you can expect that tenants get free representation by nonprofit organizations that make it very, very difficult and expensive to terminate a tenancy. When making a decision to terminate a tenancy, I always invite you to reach out to my office and we can have a dialogue before any decision is made. I want to thank all of you for attending this webinar. Please remember that I am constantly updating new laws and providing articles that are germane to property managers, real estate investors, and other people in the real estate industry. What I need you to do is find me on Facebook. If you do Yelp, please consider a positive Yelp. We continue to maintain a prominent social media presence and educate our clients through keeping them informed through social media and webinars like this. My experience is that those owners and real estate investors who keep abreast of the law are the ones that see opportunities where others don't. Again, Daniel Bornstein, thank you very, very much for the opportunity to conduct this seminar. And if you do have any questions regarding it, please give me a call. Please email me, daniel@bornstein.law. And if you want, you certainly can call me. I'm available, 415-409-7611. Thank you very much. Appreciate the opportunity.